Many real estate investors think forming a California LLC is a foolproof way to protect their assets. But what if I told you that might not be true? While LLCs can offer legal and financial protections, single member LLCs in California have weaknesses that could leave your properties completely exposed. I'm Talai, an estate planning and asset protection lawyer who founded Talai Law Offices. And in this video, I will break down what an LLC really protects, the myths you need to avoid, and the best ways to keep your real estate investment safe. What is an LLC? How does it work for real estate investments? An LLC is a limited liability company that allows you to separate your assets, your business assets, your investment assets from your personal assets. So now if there's a lawsuit filed, the creditor could possibly gain access to the assets that are placed into the LLC. However, your other personal assets, your other business assets that are outside the LLC will be protected. By using an LLC, what you are also able to do, you're able to separate your ownership of the actual property, of the actual asset, and the management. When you create an LLC, let's say you have an apartment building, you transfer the property from your name to the name of the LLC. Before the transfer, you own the property. If there was ever a lawsuit, if there was a judgment that was filed against you, the creditor would have been able to attach their lien, their judgment to the property because you own that particular property. Now in this scenario, you've created an LLC, the property has been transferred into the LLC, that's an important factor here. But now when you transfer the property in there, you don't own the property anymore. However, through the management and through the LLC, you will be able to manage the property. You have taken away your ownership away from yourself of the property, but you have still the ability to be able to manage the assets. You used to own the property personally. Now what you own is the membership interest in that particular LLC. And that becomes important because for asset protections, there are a whole different set of laws that allow and provide how a creditor can obtain your membership interest in an LLC. So, does a California LLC actually protect you? You set up an LLC, you transferred your property in there. Step 2, or I guess step 3, is to make sure you put together a proper operating agreement. With an LLC, one of the ways that we could make sure we have gotten a solid asset protection planning in place by using an LLC is that we want to make sure the operating agreement we got within our LLC is optimized and has the provisions that we need or excludes the provisions that could cause problem for us when a creditor brings a lawsuit. I'll give you 2 examples. I had a client that came in, brought the operating agreement that was written, I believe, by their accountant. Number 1 thing was that I noticed the operating agreement, the name of the company was handwritten in the operating agreement. Those are always red flags for me when I see something like that. In the LLC, it said that the member had the right to withdraw the capital contributions it had made or he had made without the approval of manager or any other member within the LLC. And that might sound really good. You know, you figure, hey, I created this LLC, I transferred my property in there, that's my capital contribution. But the LLC says that whenever I want to, I can withdraw and take out the property I have in there. For asset protection, that is not the type of provision we want to see in an operating agreement, because if there is a lawsuit filed against you, the creditor has got a judgment, they get to sort of step into your shoes, and whatever power you have, whatever thing you can do, the creditor could do the same thing. So if your operating agreement allows you to withdraw your capital contribution to the LLC at any time without okay of anybody practically, that is not a good thing for you, a great thing for the creditor because they'll be able to take the property out of the LLC. And so now you have an LLC that provides you absolutely no asset protection. Another provision that you definitely don't want to have in your LLC if you're trying to put an LLC together that provides some sort of asset protection, is that we don't want the LLC to give you power to have your membership interest transfer to somebody else without the approval and okay of the manager or the members of the LLC. That becomes important. I had another client came in, brought their operating agreement. In the operating agreement, it had indicated that the member could transfer their membership interest to anybody they wanted, their family member or anybody else. There was no restriction. There were no restrictions on the transfer of the membership interest in the LLC. Again, you could see the problem, right? If there's a lawsuit filed against you and they got a judgment, they could step into your shoe. If you have the power to transfer your membership interest, guess what the creditor is going to want you to do? They will want to have you transfer your membership interest to them. Charging order protection myth, why single member LLCs are at risk. You've done a great job. You put together a good LLC. It's got the right operating agreement. You've transferred the actual property into the LLC. And then let's say there's a lawsuit filed against you. The creditor wins. What a creditor could get to be able to gain access to your interest in the LLC is a charging order. You may be asking, what is a charging order? A charging order is a court order that allows the creditor to be able to gain access to any distributions made from the LLC to you. Very similar to wage garnishment. If there is a wage garnishment, it could be because of past due child support or alimony. I used to do family law and I used to see a lot of those things. But in a wage garnishment, before the employee was paid, whatever amount that was supposed to be paid for another lawsuit, a child support claim, it would be deducted from the wages before it was paid out. This is practically the same thing or very similar to it. So whenever the LLC makes a distribution, the creditor will be able to attach those distributions and gain the access to the amount of money that is being distributed. The beauty of having a charging order in place is that you are now placing the creditor without having any negotiations done. You're placing him on a payment plan. One of the main factors with asset protection is that we want to place a plan in place. We want to do the asset protection planning that we're doing. The goal is to make it more difficult for the creditor to be able to obtain our assets. The more difficult it becomes, two things. One is that they may not even go after this particular asset. Or even if they go after it, they will be much more susceptible and much more open to the idea of negotiating. Let's say they have $1 million judgment. They might be willing to take $250,000 to settle the case. So it gives you leverage. It allows you to protect the assets that are inside of the LLC because, again, the creditor cannot place the lien on the actual asset. What they could do, at least initially, is to get a charging order and try to take your interest, any distributions that is being made from the LLC to you. And a lot of time, the strategy is that obviously if I have a charging order against me, I probably wouldn't want to take any distributions. Maybe we're going to do more investment in the LLC. Maybe we're going to do an ADU within the investment properties that are in there. So there are other ways that I could delay distribution to the creditor with the idea that the fact that this delay is in place would enable me to, again, be able to have a more aggressive ways to be able to negotiate with the creditor, or maybe they'll just leave this particular LLC out of their claim and out of their focus to try to go after. However, this charging order that I'm telling you about, I'm going to explain to you the public policy of it and the reason why in California and many other states, almost 45 other states, I believe, have similar laws that if you have a single member LLCs, you don't really get a whole lot of charging order protection. So imagine you and I decide to start a business and you want to hire me or you want to become partner with me because I have a special skill set, which I'm not sure what it is, but you know what it is. So you want to kind of get in partnership with me, and I think you're a great investor, you have the funds, you have the connections, we get into business together. If let's say down the road, let's say months down the road, something happens and I get into some sort of a trouble. There's a lawsuit filed against me. There's a judgment brought against me. If the creditor would have the ability to come in and just take my membership interest, what would happen is that you would come to work the next day, and instead of having me, Ali Talai, as your partner, you would have somebody else. Joe Smith is now your new partner. And you would think, well, this is not fair to me. I didn't start this business to have all of a sudden another partner without my okay, without my consent. And so the public policy behind having this charging order protection was that we want to encourage individuals to get together and start a business, hire employees. And, that was the intent. And so in order to make sure this entity, this partnership sticks together, the charging order laws became effective, which was intended to protect the partner that had done nothing wrong, the partner that was not involved in the lawsuit. So in the example I just gave you, I said I got into some sort of trouble. You didn't get into any sort of a trouble. So by having the charging order, it allowed a protection so that this new creditor could not come into the LLC and all of a sudden become your partner. It said, you know what? Ali gets to stay as the partner with you. However, any distributions that Ali would get because of, however the LLC is doing, when that distribution is made out to him, his creditor can attach that. That was the idea. So as you could see, with charging order protection, it really started to protect the innocent party involved, the innocent partner, the innocent member within the LLC. So California says if you have a single member LLC, there is no other partner that would be affected. There is no innocent partner in here. So California, among many other states, say if you have a single member LLC, this charging order doesn't actually apply to this particular LLC. You would have to have at least 2 member or more members involved in the LLC in order to get this charging order. And that's the reason if you have a single member LLC in California, your assets that you place in that LLC might not be protected as well as you would like it to be. So now we got to talk about best practices to ensure LLC protection. As I just discussed, having a single member California LLC may not provide you the asset protection that you would want. So now what we can do, number one, is that we could add another member to our LLC. We could make it a 2-member LLC. However, we're talking about California. In California, another set of rules that you got to make sure you follow and you know how they work is property tax rules. So if you're creating an LLC to transfer your real estate investment in there, this is a property that you had for some time, you bought it at a much lower price than what it's worth today. If you transfer a property that you own 100% into an LLC that, let's say, you own 99% and you've given 1% to your son or daughter, that is a transfer that would cause reassessment of the property taxes for the property. And I'm not talking about just a 1% reassessment. I'm talking about the entire property will be reassessed. So in California, you definitely want to make sure you speak with a lawyer that practices in California, is aware of all the laws that relate to LLCs, California LLCs. How do you make the transfer of the property in there without having the property taxes reassessed? That becomes very important. A lot of times when we add a second member, we actually use a trust. So instead of adding the child directly as a member within the LLC, parents, again, most of the time want to make sure they still have control over the LLC. They want to make sure that if something happens to the child, maybe they go through a divorce, maybe there's a lawsuit against them, we want to protect that 1%. So in most cases, what I would suggest is actually creating a second trust, an irrevocable trust or another type of trust that could work, in adding that second member that way. The other way to fix this problem with single member California LLCs is to use a holding LLC strategy. So California LLC is going to be owned, in most cases we use Wyoming, a Wyoming limited liability company. That would allow us to be able to use the laws in Wyoming, and Wyoming is one of the few states that allow charging order protection even if you have one member. We can not use any LLCs, and we could use a limited partnership. We could use a California limited partnership or an Arizona limited partnership, or realistically any other partnerships that you could form in the other 49 states. However, that part of it will really depend on where the property is, what other asset protection goals do we have. A lot of times we use Arizona limited partnerships. There are special nuances in the statute, and that would help us to provide and do a better asset protection planning for you and for your family. We just covered how California LLCs work and if they actually protect your assets. But what if those same assets are stolen away by your in-laws when you pass away? Check out this next video where I will explain exactly how to keep your in-laws out of your state. See you over there.